Welcome to the Data Protection Café in the heart of Munich. Today's topic, correct response to information requests. The European Data Protection Board has released its final guidelines, and today we'll examine them in detail. The European Data Protection Board, representing the European supervisory authorities, recently adopted their final guidelines on handling information requests in the month of March of this year, following a public consultation process that took place earlier. Now in April, the final version has been published, which regulates the handling and provides recommendations on how information requests should be handled by controllers. The guidelines were preceded by a public consultation, and in March of this year, the final version was adopted. It has now been published in April by the European Data Protection Board, as announced by the European Data Protection Board in their recent statement. You have the option to find the link to the guidelines below in the comments section of this page. The European Data Protection Board, composed of representatives from national data protection authorities, thus provides controllers with guidance on how to handle information requests from data subjects. We recall that Article 15 of the General Data Protection Regulation, GDPR, displayed here, grants data subjects the right to find out from controllers whether their personal data is being processed, what specific data is being processed, and to receive additional information, particularly regarding the duration of storage and the purposes of processing. The guidelines contain a series of clarifications that have simply emerged in recent years due to the different interpretation practices and therefore attempt to achieve a certain harmonization at the European level. Let's look at a few of these aspects. Firstly, the controller is not allowed to question the motivation of the data subject. So he must not confront the requester, the data subject, with, "What do you want with your right to information here?" You are unable to do anything with that. It is nothing that can be presented to the data subject in any manner or form. Second clarification, the data subject possesses the choice of determining the manner in which they assert their right to information. He can decide for himself whether to send it by mail or email to the general email inboxes. If the controller operates a portal, which is frequently the case with larger websites, that is utilized to identify the data subjects and where the data of the data subjects is then automatically provided in the portal in order to respond to the information request from the data subjects. Then, obviously, this is highly practical, but the controller is unable to explicitly state that this is the sole process step you may choose here in order to exercise your right to information. The data subject has the freedom to choose the means. In the end, if the controller is unable to sufficiently identify the data subject to respond to the request, they must inform the data subject of this and request additional means of identification in order to proceed with the request. In certain situations, like when it comes to payment data, a copy of the ID card may also be requested by the relevant party or authority for verification purposes. Exercise caution. These documents must be redacted to the extent that they contain information that is not necessary or relevant for identification purposes. There is also a corresponding passage in the guidelines that specifically addresses this issue. The document further clarifies that LOC files may also contain personal data and are therefore generally covered by the data subject's right to information as stipulated in the guidelines. Partly controversial due to differing views among supervisory authorities, guidelines offer clarity on this particular point of contention. In addition, it is worth noting that the guidelines also specifically mention that the provision of information can be done electronically, including via email or through a tool that provides access to the relevant data. The guidelines also state that in such cases, appropriate security measures, encryption, and similar options should be chosen to maintain the corresponding information security requirements for confidential files. And last but not least, the document also mentions that for very extensive data sets, which is particularly relevant for log files, a multi-stage approach can be selected in responding to the data. This means that the initial response to the data subject only includes specific basic data sets from the log information and then provides the option for the data subject to be informed that if they want all information, they should write to us, and we will then provide them with all log information. The guidelines also clarify that the 1-month deadline should be considered as a rule and should only be extended by an additional 2 months in exceptional circumstances. This should be set aside for intricate situations, such as addressing requests for information in the context of an employment relationship that requires a response. And last but not least, the increase in affected requests. So, in the event that a data subject, for example, makes a request for information on a monthly basis, it is not considered to be excessive, even if the data sets undergo regular changes. However, the controller has the right to request a fee from the data subject to respond to frequent information requests, which is commonly referred to as a processing fee. Those who derive pleasure from the present will have a remarkable history in the future, and that is the ultimate finding. When dealing with information requests, the relevant internal departments, that is, their employees, should be properly trained. The 1-month deadline is applicable for responding to information requests. Moreover, it is imperative to clearly identify the requesters before providing the relevant data to ensure accuracy and compliance with regulations. And the data subjects are at liberty to select the communication channel through which they direct the respective information request to themselves. The information must encompass all of the stored data that you possess pertaining to the individual in question. And for very extensive data sets, the provision of information can be done in multiple stages. What else has occurred in data protection? Tesla employees have internally exchanged videos of Tesla customers. Further information can be found in the link provided in the description. Enjoy reading.